topic would be the continuation from the previous day's topic that we discussed. We actually ended at section 8, and today we'll start with section 9, then proceed to section 10, and then 11. Uh, whereas section 9 deals with jurisdiction generally of the civil code, section 10 and 11 go to the next level and they actually go ahead and impose a bar when a suit is to be not entertained. We'll discuss them together with this section as well. So, without wasting time, let's just start with the presentation. There was some issue with the PPT today, so you'll have to bear with me because I'll be projecting the PDF file that I have. I couldn't just make the PPT. I mean, I made the notes. After that, when I was preparing the PPT, for some reason it was not happening. So just bear with me because the fonts will be a little smaller. Nevertheless, I'll prepare the PPT and share it with you along with the previous day's class. Some of you were asking for the same. Okay, someone confirm me that this screen is visible, please.
Yes, sir.
Yeah. So, so before going to section 9, we have to know what do you mean by jurisdiction. We all know that jurisdiction is nothing but actually the power of the court to hear a particular issue. If that power of the court is vested with that, then we tell that yes, the court has the jurisdiction to try the issue. In Hadia versus Ramchandra case, it was enumerated by Supreme Court that the jurisdiction refers to the power to hear, determine, and pronounce judgment on the issues before the court. Another case, Major S.S. Khanna versus Big Dillon, where it was held that issue of jurisdiction is the first issue that is supposed to be decided by the court. So we all know when a plaint is filed for institution of a suit, and then a written statement is filed by the defendant, the first thing that the court does is that frames the issues. That is, in fact, the anonymous, the in fact the analogous provision. Analogous provision, which is there in CRPC, which talks about cognizance. When a judicial mind is applied to a criminal case in a criminal court, that is called cognizance. Whereas here in civil case, framing of issues are done, and that is the first step when the civil court actually applies its mind. And the first issue would be, in fact, determining that whether the court has jurisdiction to try that particular suit. Without it determining that issue, you can't probably go ahead with other issues. We all know that jurisdiction are basically three types. One is subject matter jurisdiction. So basically, if we say that this is a small causes court, that means the court of small causes only will deal with such matters. If we say that this is a REIT court, then it will deal with REIT cases. If it is a civil court, it will deal with civil cases. So subject matter jurisdiction. Second is pecuniary jurisdiction, which we already discussed in section 6 of CPC. That is whether the power of the court, whether the financial limit that is fixed by the legislature to try a particular case or to dispose of a particular suit, that is not exceeded by the court. That is a mandatory thing, pecuniary jurisdiction. And the third one is territorial jurisdiction, that is the geographical limits. So basically, if the geographical limits of a court is fixed, that only a jurisdiction of Cuttack will be under its purview, then cases from Bhubaneswar cannot be filed before it. Also, there is another type of jurisdiction, that is original, that is inherent jurisdiction, and the opposite of that would be appellate jurisdiction. So basically, these are the types of jurisdiction we all know. In Lal Modi versus DLF Universal Limited, it was held that even though the court does not have a territorial jurisdiction, the decision can be pronounced if the other party agrees. So my point here is, if it is a breach of a pecuniary jurisdiction, there is no cure to that. So, so if that's a disease that has taken place to a suit, that there was no pecuniary jurisdiction and it has been tried, or otherwise, that would be not curable. But if there is a territorial jurisdiction and the lack of it is there, but the other party actually comes and says that no, it's fine that Cuttack court decided, even though the case should have been decided by the Bhubaneswar court, still then it would be fine. So coming to our main topic, that is section 9, that says that courts to try all suits of civil nature. So the section says that courts to try all suits of civil nature except whose cognizance are expressly or impliedly barred. This is a very small section, but nevertheless the most problematic of all, because the interpretation, if you can interpret this in a particular manner, then probably all the issues that will come, because a lot of short questions in preliminary will come where you have to decide that whether this suit is of a civil nature or not. So if you do not know the law, you are bound to commit mistakes, because there will be n number of suits, and you though I will try to enumerate a few of them which you may memorize, but then nevertheless, if you do not know the fundamental notion how the civil nature suit is decided, then in that case you will probably always be committing errors, and I don't want you to do that. So just remember this much, that when they say that it's a suit of a civil nature, that means the principal question that is involved in the suit must be that to determining a private civil right. So basically, so there might be 3-4 issues in a suit, doesn't matter. There might be subsidiary issues which will not be civil in nature, because there will be any religious question is involved, or any other such issues are involved which are not civil, such as political issues. But the most important issue, that the principal question that is to be determined in the suit, that must be as determination of a civil and private right, and that must be a civil obligation that is there, and the enforcement of the private right, that must be the principal question involved. And in that case, that will be a suit of civil nature. So anytime a question comes that whether this will I'll give you an example, I'll give you examples, and we'll all discuss how it is a suit of civil nature and how it is not a suit of civil nature. We'll discuss some of the examples, and probably that will make you more clear. Explanation 1 of section 9 says that right to property or an office is contested and the suit is of a civil nature, then even if religious rights and caste related questions are being determined, or the subsidiary issues, even if they are not of civil nature, they can be tried along with principal questions of civil nature. So the point being that in a suit where there are 3-4 issues, and one of such issue, which is the principal issue, that is in fact the right to property, or an office, right to an office is being contested. So that is a civil nature suit. In that case, even if there are subsidiary issues which involve religious rights and caste related questions, they will be of civil nature. To make it more clear, that if so let's discuss the examples that will in fact give you a clear picture. The explanation 2 will discuss it first again. This explanation 2 says that whether fees are attached to that office, or any place is particularly attached to that office, or to that right to property which is being challenged, those places or fees attached, those are immaterial, because if there is a principal issue which involves a right to property or a right to office, or ends up being a right, or ends up being a suit of civil nature, in that case subsidiary issues can also be determined, though they were not originally involving civil rights. So the uh, the important ingredients of this section would be that that the cases tried in the court should be of civil in nature. Court should not be expressly or impliedly barred from trying the case. Oh, I probably forgot to explain you what do you mean by expressly and impliedly barred. Expressly barred, when I say it, it means just one thing. It just means that there is an express clause by the legislature enumerated in an act which bars the civil court from the exercising the jurisdiction over the suit. For example, in Surfacy Act, the civil court is barred. For example, in Cooperative Societies Act, the civil court is barred. That is an express provision made by the legislature by virtue of for that guardianship minority and guardianship act. In that case also the jurisdiction of the civil court is expressly barred. So in such cases it will be deemed, it will be obviously presumed that the court will not be having any jurisdiction. But there can be other cases as well where, though there is no express bar made by the legislature, there will be an implied bar. For example, uh, if there is a suit which involves the violation of a right, not a right, in fact, violation of a contract which was opposed to public policy itself. To be more specific, if someday X comes and gives Y his room, his house, to be used as a gambling den, and in that case, if Y doesn't perform his part of the obligation, that he does not pay the rent or otherwise, then X cannot probably ask for any relief from this civil court, because uh, such a thing has been impliedly barred, because it is opposed to public policy, because there are immoral things or things which do not uh, confirm the ordinary laws of the land. So in that case, there will be an implied bar. So in that case also, it will be presumed that the court will not take cognizance thereof, and hence the court will not try the same. So we discussed that suit should be civil in nature. Then yes, we'll discuss now the examples of the suits which are of civil nature. First is suits for rent. Yes, you gave someone your room on rent and he did not pay you. You can approach the civil court. Suits relating to right to property. You want to succeed to your father's properties and you file a suit, that is well maintainable. Suits for dissolution of marriage. Your wife is being cruel to you. There has been a restitution of a conjugal right or something of that sort. You approach the civil court. That will be very well maintained by civil. Suits for the rights of franchising. This has in fact been asked many times in preliminary questions also, that whether a right of franchisee will be, that mean a right to cast a vote, while franchisee has in right to cast a vote, whether that is that particular right can be challenged in a suit before a civil court. Yes, in Shailendranath versus Ramchandra, it has been held that yes, it can be challenged in a civil court, because the constitutional right of casting a vote is there. Probably Article 326, if I'm not wrong, that is there. I'm subject to correction, please. I think it is Article 326. Yes, Article 326 probably says that there is a right to cast a vote, and in that case, if that right of yours is violated, then you can very well approach the civil court. Suits relating to rights of worship, that is, you may ask that this right of worship is probably a religious right. How is it being treated as a suit of civil nature? No, because there are other issues which is principal in nature, and that is in fact a civil nature right. For example, if you have a right to worship, that means you have an office, you are a priest of that particular uh, temple. You have a right. You have a though you have a right. You also have certain duties that you have to go to the temple. You have to open that temple. You have to offer the prasadam, and then you have to make sure that all the cleaning and all the activities are done. So you have certain duties. So, so that an office is actually being fixed. In that case, in Narhari versus BN Temple Committee, it has been held the right to worship is also uh, can be challenged in a civil suit. Suits relating to taking out processions. So basically, that is also a constitutional right, because yes, you can very well right to expression is there, right to speech and expression is there. That is in fact a part of taking out the procession is a part of a right to freedom of speech and expression. In that case, Saik Piru versus Kalandipati, it has been held that yes, it will be a suit of civil nature. Suits relating to right to share in offerings. So, for example, in Jagannath temple, if there is this provision that some abhada will actually be coming to someone's house because they have a particular offering in that temple, then in that case it will be also a suit which can be challenged in a civil court. Suits for damages for civil wrong, that will be challenged. Suits for specific performance of contract or damages for breach of contract. This is a generic thing that you need not. I need not specifically elaborate. Suits for specific relief, yes. Suits for restitution of conjugal rights, I discussed. Suits for on an account. So basically, an account is in question, and you believe that the accounts has been wrongly maintained. In that case, that will also be uh, uh, that can also be challenged. Suits for right to hereditary offices. So if by virtue of the fact that you inherit that office, if that right has been taken away from you, then also it can be challenged. Suits for wrongful dismissal of service and salaries. In that, if you have been wrongfully dismissed, that can be challenged, because yes, of course, it's a civil nature. Suits relating to partnership, that can be challenged. Suits by government servant for arrears of salary, that has been held in state of Bihar versus Abdul Majid, that yes, it can be challenged in a civil court. Right to remain in the community, yes, this in fact has been enumerated in Mansoor Ali versus T. Ahmad, that right to remain in the community, though it may sound again like a right which is not a civil right, and probably it relates to caste or religion or something of that sort. No, it is not, because yes, you have a right to stay anywhere that you desire in the whole of the country, and if someone does not allow you to do that, then you have a right to challenge that in a civil court by exercising it as a civil right. Examples of suits which are not of civil nature: suits on expulsion from caste. So in that case, if you have been expelled from your caste itself, so basically you are a Brahmin and you have been expelled from that Brahmin community. In that case, no such civil right is involved here. You're getting it, because there is just a question of your caste, and they're not particularly debarring you from the place itself, or your civil right as such is not being affected. And in that case, it will not be a suit of civil nature. Suits involving purely religious rites and ceremonies, if there is purely religious rites and ceremonies, then in that case also a suit cannot be done. So for example, I when we were discussing the sixth point, that suits relating to take out procession, if you want to take out a procession, yes, that's a civil right. But you want to take out a procession carrying an emblem, carrying a religious emblem or carrying a religious symbol, in that case, that will not be in fact a civil right, because here you are actually taking out a religious procession. In that case, it will not be exclusively civil right. Suits relating to political questions, this questions can also be not challenged. Suits for upholding dignity and honor. right in respect of voluntary offerings. All of this cannot be challenged. So my question time, I have to ask you this question: that fees, if not attached to the religious office, then what will be the position? So basically, uh, there can be two instances in religious offices. Either fees will be attached or fees will not be attached. So basically, a priest is actually offering his puja to Lord Shiva in a temple, and he is getting some fees by that trust in a particular case. And there is another case where if priest is going and he is not getting anything, just the voluntary offerings that he gets from all the people that come to the temple, that is the remuneration. But in fact, that's not the remuneration, but then the fact that he's getting it, let's call it like that. But then the fees, if they are fixed as a salary, or he's getting some fees because of the fact that he's holding a religious office, then what will be the position? And if he is not getting any fees, then what will be the what will be the position? That is the first question. And the second question is, for example, take into consideration Guru Sankaracharya or Dalai Lama for that matter. So whether their position is something which can be challenged if that is taken away later. So whether that can be challenged. Uh, Please answer me these questions at the end of the session. Mark them or screenshot them so that it will be easier for you to remember. Uh, uh, yes. Then coming to expressly barred, we have already discussed that when the legislation restricts the scope of jurisdiction of the civil courts to try a particular class of suit, that is called expressly barred. Shankar Narayan versus K. Sridevi, it was held that civil courts have primary jurisdiction on all civil matters unless it is expressly or impliedly barred. So basically, you have to know that civil courts are actually your one-stop solution for everything. There is no other remedy. The only remedy available to you must be the civil code. Yes, of course, there is the provision of writ, but then that actually is narrowed down by the fact that if there are no rights, constitutional rights or fundamental rights are not in question, then in that case you cannot go before a writ code. But in civil code there is no such bar, and you don't have any other relief. You have violation of any right, you probably come to the civil code. But of course, if it is not expressly barred or impliedly barred, then in that case the civil code must assert the jurisdiction, right? Impliedly barred means restriction is being imposed on the court by the general principles of law. We have already discussed this. Then coming to the burden of proof, that who has the burden of proof here? That here the burden of proof lies on the party who claims that the court does not have the power to try the case. So basically, whenever it is alleged that court does not have the power to try the suit, he will have to come and show how the court does not have the power. It is not the court who has to show that how I do not have the power. The court will infer that it has the power unless there is any express bar or implied bar. Now the person who actually is of the opinion that court does not have the power will show it otherwise. Abdul versus Bhavani, in this case, it has been held that presumption should be made in favor of the civil court and exclusion of jurisdiction shall be strictly construed. So basically, if there is no strict showing of the fact that yes, this is how the civil court's jurisdiction has been excluded, and in that case, the presumption will be made in favor of the civil court that it has jurisdiction. The section 9 is both positive and negative in the sense that if on one hand it says that court will try all suits of civil nature, but again in the second stage, I mean the second part, it strictly says that if it is not expressly and impliedly barred. So basically the legislature here has tried to draw a balance that how the all the rights of the people will be protected, but nevertheless if there is any other particular forum or if the such right should not be entertained at all, then in that case the civil court should not interfere at all. State of Andhra Pradesh versus Majeti Lakshmikant Rao. uh, the Supreme Court has actually gone ahead to fix two tests about the exclusion of jurisdiction of the civil court. That is, first one would be that there should be a legislative intent to exclude the jurisdiction of the civil court, and second would be that there should be an existence of an alternate remedy. So, as I told you, if there is an alternate remedy, you do not approach the civil court. If there is an alternate, so if SURFACE Act, there is a debt recovery proceeding. In that case, you have to approach the debt recovery tribunal. You cannot come to the civil court and say that no, this you have to entertain this as well. But the legislative intent to exclude the jurisdiction of the civil court, that must be there. These two tests are the litmus test you have to go through to make sure that whether the jurisdiction of the court is vested or divested. Now coming to section 10. I hope section 9 we were clear, and now we'll discuss section 10 that deals with res sub judice. Res sub judice in Latin means under judgment. So basically, this says that if there is a suit which is pending, if there are two, so basically the rule says that when there are two or more cases, and those two cases are between the same parties in same capacity or the same title and on the same subject matter, and then and both the suit are in fact before a competent court, then the competent court has the power to stay the later proceeding. So here the thing involved here is that if there are two suits and the first suit is pending before a competent court, then it must be the prudent thing to do that you have to stay the later suit, because if there is any problem arising from the same, he has a way to appeal. Why to file a fresh suit? Because of the fact that this is nothing but based on the principle of natural justice, that people should not be harassed unnecessarily. There should not be, one should not be just vexed twice or thrice. If you allow this, then there will be multiplicity of proceedings. For avoiding such situation, res sub judice principle comes to our rescue. So it provides the rule of stay of suits pending adjudication by a court. So the ingredients of this particular section are that I have divided. Then I will discuss one by one. No court shall proceed with the trial of any suit. So basically, it says that if there is any trial of a suit is right now going on, the court shall not proceed with the trial of that suit in which the matter in issue, the principal matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties litigating under the same title. So you have to remember all these key points: same parties, same title, same issue, before a competent court. All these are key points, and in the same court or any other court in India, or in any court beyond the limits of India established or continued by the government and having like jurisdiction, or before the Supreme Court. Basically, so it says that if there is a court, Privy Council, for that matter, it was before our independence that Privy Council's judgment, if there was a case pending before the Privy Council, that was also under the purview of the section. Now, right now, there is no such thing because all the courts within India are only under the purview of this section. So it says that if these ingredients are satisfied, then in that case, the court will stay the latest proceeding and it will go ahead and dispose, whether that court or any other court, doesn't matter, after only the disposal of the first case, first suit. There can be a reversing mechanism applied to that stay, and it can be again lifted in order to make sure that if there is any problems or there is any grievance of the parties who has brought the second suit, then that can be addressed then. But till that, the second suit must be stayed. The explanation says that the pendency of a suit in a foreign court does not preclude the court in India from trying a suit founded on the same cause of action. So basically, if there is a foreign court, if there is a suit pending, then that does not preclude the court in India from trying a suit founded on the same cause of action. It can be very well filed. So the stay must be of the latter suit and not of the earlier suit between the same parties. At time and again said you can't stay the earlier suit, you have to stay the latter suit. The word suit here includes an appeal. It does not include it includes an appeal, in fact, but it does not. I'm forgetting. It does not include. For now, remember that the word suit includes an appeal. So now the conditions of res sub judice are that, as I said, there must be two suits previously instituted and subsequently instituted. Second is matter in issue in subsequent suit are directly and substantially in issue in previous suit. That means same matter. Two suits, same matter. Third is same parties. Fourth is pending suit. There must be a pending suit. Fifth is competent court. Sixth is same title. All these points are satisfied. Then the court has only one duty to stay the latter suit. So another point we have to know that whether the court can apply this section where points at issues are different. No, it cannot do so, because if there are, just because there are same parties, so all these points have to be categorically satisfied. So even if they are same parties, even if they are in same title, if one of the points is taken away, that is the matter is different. Basically here they were questioning the right to property, but there they are questioning mean profits or right to possession for that matter. In that case the matter, subject matter becomes different. So here court cannot apply this rule and stay the latter suit. You'll have to hear both of them analogously, they'll have to be heard. So even if there are some issues in common and there are other different issues, then in that case also the section will not be applied and it will not be stayed. As we discussed, what are the purposes of res sub judice? That is to protect a person from multiplicity, avoiding conflict of decision, protect the litigant from unnecessary harassments, etc. So this is an inherent power to stay that is there with the court. When all such conditions are satisfied, we will just go ahead and stay the latter suit. Although the provision of section 10 is mandatory, but this provision has not taken away the court's inherent power under section 151, so as to stay the proceeding on the facts and circumstances of a given case to secure the ends of justice where section 10 is not applicable. So yes, to make it more clear that even though all conditions that we discussed, even if they are not satisfied, the court though cannot grant a stay under section 10, it can very well go ahead and grant a stay under section 151, applying the inherent power, because unlike in a criminal court, the civil court from the stage of the civil judge junior division has unlimited power because it has got the inherent power. While in a criminal case, inherent power only vests with the high court, but in a civil court has inherent power, and that says that you don't have to actually abide by CPC. CPC is for the aid of the court. So basically you can actually formulate any other means if you think that will help you in better determination of that question. So in that case, even if all these points are not satisfied, for the ends of justice, the court can very well stay even if section 10 is not applicable. But yes, to grant a stay under section 10, all these conditions have to be satisfied. Do I have a low battery? Yes. Section 11, res judicata. So coming to section 11, that is res judicata, probably everyone is aware of that res judicata means that once adjudicated, then yes, the Latin means that matter once adjudicated cannot be re-adjudicated. That is what res judicata is. And the section says that no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties litigating under the same title in a court competent to try such subsequent suit and has been heard and finally decided by such court. There are stark difference between res sub judice and res sub judicata. For the fact that res sub judice only deals with the fact that there is a pending case which is not decided, but in res judicata the case has been already decided. And that is the reason that the main difference lies here, that in res sub judice it is a pending suit, where sub judice means it is already pending. Judicata means it has already been decided. So the difference here is that res judicata, the matter has already been decided, and the matter was directly and substantially issue is actually the same as that of the previous issue, but now with the issue which has come is actually the same as that of the previous suit, and it has been held. It has the case has been filed in a court competent to try such subsequent suit, and it has been heard and finally decided on merits by such court. Then that case the principle of res judicata shall apply, and such court will not in fact go ahead and trying or hearing the same. This in fact is based on three popular maxims, that is nemo debe bis vexari pro una et idem causa, that is no man should be punished twice for the same cause. Interest republicae ut sit finis litium, it is in the interest of the state that there should be an end to a litigation. And res judicata pro veritate occupitur, that means a judicial decision must be accepted as correct. So the intention is nothing but giving finality to the judicial decisions to make sure that there is an end to the litigation once and for all. Because if it is just allowed, then why is there a provision of appeal? If you are not happy with that, you appeal. There are appellate provisions, and after that, when you exhaust your remedies, you have to accept that this is the law of the land, and according to the law of the land, I am not entitled to get the particular relief that I'm probably praying. So in that case, you'll have to accept it. If you do not, then probably there will be chaotic situation, because people can just go ahead filing case after case, and there will be never a finality to the litigation. And on the already lagging judicial system, I must be excused to call my system lagging for the fact that yes, because there are lots of cases pending before the court, and Indian judiciary is actually one of, though the judges are quite learned, it is still lagging behind in the judicial ranking system. And Odisha, in fact, has come down also very considerably this year as well. So all this taken into account, if there will be no end to litigation, the situation would further deteriorate. And so that matter, for that consideration, res judicata principle comes to our rescue. So first laid down in Duchess versus Kingston case in 1776, and it has been reiterated by Supreme Court in Daryao Singh versus State of UP, in which the principle of res judicata was first laid down, and the matter in issue, which has already been tried by a competent court, then trial between the same parties in respect of the same matter shall not be allowed. So now coming to the explanations of res judicata. Before that, we'll discuss essential conditions of res judicata. So the essential conditions are that the matter directly and substantially in issue in the subsequent suit and former suit, these both the matters are same. Parties of the former suit and subsequent must be the same. So parties same, subject matter or the matter is same. Court which decided the former suit must be a competent court. So the matter which was decided by the former court, that must be a competent court, and the matter should have been decided. That matter must have been decided on merits, and final decisions should have been made after hearing. If these things are done, so why the hearing part is important? Because if there is no decision on merit, it will not be presumed that it has in fact been decided by a court. So, for example, if there is a consent decree, we were studying consent decree yesterday. So if there is a consent decree whether that will be in fact binding as a res judicata. No, it will not bind as a res judicata because the court has not applied its mind. The the suit was filed, the written statement came, and when the court was about to apply its mind and about to hear the matter, both the parties came and filed for a petition applying for a consent decree because they want to reach to a conclusion. So basically, they decided within them. So this is not something which has been decided by the court by after hearing. So that consent decree, though it has disposed that particular suit, it will not operate as a res judicata. Now coming to the explanation one, which says that formal suit. What is a formal suit? So in res sub judice, a formal suit is the case which has been instituted earlier. But in a res judicata, but in section 11, a formal suit which has been decided earlier. So for example, to give you an example, in 2000, let me just ask you this question. Yes, please tell me. Someone please tell me if a suit has been instituted in 2012 and another suit was instituted in 2014. The first suit is pending, which was instituted in 2012, and the second suit, which was instituted in 2014, is decided in 2016. Right? And this first suit, which was instituted in 2012, I mean, the point of time, the institution point of time was earlier. So that was decided later, as in after 2016. So which will be the suit, which is the former suit here? Someone asked me that. Someone answered that question.
Hello, good evening, sir.
Yes,
Sir,
evening.
Sir, explanation 1 to section 11 says that former suit shall denote a suit which has been decided prior to the suit in question, whether or not
Yes.
it was instituted prior thereto. So even if
Right.
the suit has been instituted earlier, it will
Right.
it will be later then.
That is in fact my point. That is in fact I wanted to say that it doesn't matter whether it was instituted prior to the prior in point of time. That doesn't matter. Whenever it was decided, that will be the day when we will consider that this is the former suit for the purpose of deciding res judicata. But yes, this question, when it will be in context to section 10, the answer would be totally different, because the answer would be the earlier instituted suit. You're getting it? So that is the explanation one. And then, so as I wrote, res judicata depends on decision, but in res sub judice, institution matters and not the final decisions. Now coming to kinds of res judicata, that is actual res judicata and constructive res judicata. So actual res judicata or direct res judicata, it means that a matter actually resolved by the court between the parties in earlier suit cannot be reopened through subsequent suit. So basically, whatever we study right now, that is res judicata. So basically, resolved by the court, again you cannot reopen the same. That is direct res judicata. And explanation 3 in fact makes it clear about that that by saying that the matter must be in the matter must in the formal suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. If that is the case, then in that case direct res judicata will apply, and the former suit will act as a bar to the latter suit, and the latter suit cannot just go ahead with the trial. Now coming to constructive res judicata, which is explanation 4. This basically probably I get a lot of questions from here that it's a complicated concept, but it is not. It's just based on the simple fact that you cannot sleep over your right. The normal principle is that if you have a right, you exercise it. If you don't, you lose it. And explanation 4 says that it is in the interest of justice that a party should bring forward his whole case in respect of the matter in suit. So you have a suit, you have filed a suit, there are certain grounds you were to take, probably that would have helped your case, and you did not take those, probably thinking that I'll use them later, and probably did not use them throughout the suit, and your suit was decided, it was dismissed, and then later you will file a suit claiming that no, I could not take that particular plea, now I want to take, and please allow me, because that plea I had not taken, it will not be, it will not be allowed. Yes, of course, if that fact was not known to you, that whatever plea you are alleging right now, that was not known to you, or it was not due to your knowledge, I mean, not in your knowledge and not due to your mistake, and in that case that can be an exception. But if there is a matter which might and ought to have been made ground of claim or defense in a formal suit, but a party ignores it, when I say ignores it, it does it purposefully, then the issue shall be deemed to have been a matter directly and substantially in such suit, and which has been decided. It will be presumed that it has been decided. It is a deemed res judicata. Constructive res judicata is a deemed res judicata. So it will be deemed that the issue has been decided. Now coming to the res judicata and difference between some. No. This is in fact a concept of res judicata. So basically, if there is an ex parte decree, and there is whether a res judicata will apply to that. So the answer would be that even if there is an ex parte decree, it will be deemed that it has been decided as if the party was present, because here the plaintiff came, filed a suit, the court issued summons again, sent notice through special messenger, published in a newspaper, you still did not appear, you chose to ignore your right. Now it will be presumed that yes, you were present, as if you were present, as if it was a bi-party decree, and ex parte decree is in fact presumed as a bi-party decree, and in that case, it will be presumed that you have taken your taken your stand, and it will, res judicata will apply. But yes, as I said, not in a consent decree, because in consent decree, both the parties simply come and give a application to file a consent decree, and the court does, without applying its mind, whatever are the terms of the consent decree that they want to draw, the court just simply enters it. In that case, this doctrine of res judicata will not apply. Now coming to foreign judgment and res judicata, we have already discussed. Section 13 provides that a foreign judgment shall be conclusive. We discussed already. Res judicata and res sub judice, what are the difference? Yes, this is one important thing that we have to know. That is, res sub judice is mentioned in section 10. This mentioned in section 11. Res sub judice relates to matter pending judicial inquiry. That means the trial is pending, but here in res judicata, the trial has already taken place and the matter has already been adjudicated. The res sub judice bars the trial of the suit, but res judicata bars filing of the suit. That is the prime difference. Now, the difference between res judicata and estoppel would be, while the res judicata is based on public policy that the litigation should be given a finality, estoppel is a part of law of evidence, where a man cannot change his stance once he has taken it. Res judicata prevents someone from saying the same thing in different litigations, but estoppel stops him from saying different things at different times. Res judicata bars the trial, whereas estoppel only stops a certain piece of evidence from being taken on record. Res judicata outs the jurisdiction of the court, estoppel stops a party. There is nothing to explain, because we all can know what are the differences. So it is similar things. That's the reason probably that might be questioned. So I thought of keeping it in this slide. Res judicata derives from a court decision, whereas estoppel derives from the facts asserted by parties. Explanation 5 that of the res judicata says that if there is a relief claimed in the plaint and it has not been granted by the decree, court basically did not mention about that claim, then it will be deemed to have been refused. So basically, it will not be a ground that the party will again come and say the court did not discuss about that claim. So in that case, let me file another suit. No, you can't do that. If a relief has been claimed in the plaint, but court did not expressly granted by the decree, it will be presumed that it has been refused. So these are basically nothing but to aid the principles. The explanations have been added later. Explanation 6 would be it applies to the representative suit. That is, if the persons are litigating bona fide in respect of a public right or of a private right claimed in common for themselves and others, all persons interested in such rights shall, for the purposes of this section, be deemed to claim under the person's sole duty. So that means that if a person has filed a suit in the representative capacity, we'll study that later. So for now, Gram Panchayat, suppose the Sarpanch has filed a case on the uh, from the side of the village. And in that case, if that is dismissed, and then later another person cannot come again from that same village and say that I had not filed that same case, because this is also to make sure that finality of litigation is there. The res judicata principle is also applied to representative suit. Now coming to explanation 7, which says that it also applies to execution proceedings. So basically, it has been given to a suit. That means if it will be presumed that in execution proceeding also the res judicata will apply. So you can't file execution case again and again if it is not in your favor. Explanation 8 would be it applies to courts against courts of limited jurisdiction. So this point is that if there is a suit which has been decided by a civil judge junior division, we were studying that the pecuniary jurisdiction of the civil court in a civil judge junior division, which is not a civil judge junior division anymore, they are just called civil judges. So if a civil judges uh, jurisdiction is 50,000 and he has a decided a case involving a land in 1990. Now the matter of now the value of that land has increased to 2 crore. So you can't again say that then the suit was decided by civil judge, which was having a pecuniary jurisdiction of 50,000. Now the land's value is 2 crore. So obviously that court does not have jurisdiction, and hence let me just file another suit because that court was not competent. No, it can't. Limited jurisdiction means that court has ceased to have jurisdiction now, but previously it used to have good jurisdiction, right? Previously, the value of the land was below 50,000. Now it has come to 2 crore. Now it has seized jurisdiction over the matter. But yes, then when it was decided, he had jurisdiction of that same, and it was decided on merits. In that case, that will apply as res judicata in later suits as well. Another some miscellaneous things are it applies to civil, quasi judicial, and arbitration proceedings. It applies between co-plaintiffs and co-defendants. It applies to minors also if they are properly represented. It applies to writ petitions also. But yes, you have to remember that in habeas corpus cases, the principle of res judicata will not apply, as held in Daryao Singh versus State of UP, 1961. It does not apply to consent decree, as we discussed. Does not apply to income tax proceeding, and it does not apply where substantial question of law is. Substantial question of law, yes, we'll discuss that in detail later. So this more or less completes our discussion on jurisdiction of the civil court vis-a-vis the res sub judice and also res judicata. I hope I was clear to you. If there is any other doubt, you may ask, but my battery is low. Subject to that, uh, let quickly, if in 2 minutes there is any doubt, you may ask, or otherwise you may post it in the group or ask me personally on WhatsApp, and I'll make sure that I answer your doubts. Right now I probably can't because my battery is 3% right now. Still then 1 minute I have if there is any doubt. Okay, so may I presume that everyone understood everything properly. And in that case, it's, it's my pleasure. Anyway, you have a great evening. And if there is any subsequent doubt, you may post them in the group. Thank you so much. And the next class would be taken probably next week on Sunday. Sunday.
Thank you, sir.
Thank you. Bye.
Thank you, sir.